Hello, everybody. We made it to week 5. I probably start every single lecture like this because I'm awkwardly talking into a laptop. But all right, this week we're learning about the judicial branch. So at the end of this week, by Sunday, you should be completing your second quiz, which covers executive, legislative, and judicial branches. And really, we're rounding out the second of a 4 sections of this course. And today, let's learn about the judicial branch. So learning objectives today, we're really just looking at understanding the structures of our federal court system, interpret the differences between the state and federal courts, and really look at the differences between a judge and a justice. Very simple. We're also going to explain how and who appoints judges on both the federal and state level, understand that process, identify the ideological makeup of our current Supreme Court, and examine some of their current rulings. And we're doing this through a lens that's also taken up in our textbook, so I'll also give you a few page numbers if you wanted to read into that in more detail. We're going to recognize some landmark decisions, examine what landmark rulings are at large, and distinguish the checks the other branches have over the judicial. Because remember, judicial's branch over the executive and legislative is pretty simple. They determine the constitutionality of executive and legislative actions. But let's see how their powers are kept in check. So first off, what is the judicial system? Well, it's where our judges reside. It is our federal court system. We have a 3-tiered court system. At the lower tier, I have a graphic on the next slide I'll walk through with you as well. But we see on the lower tier, we have the district courts. We have 94 different district courts. And within these courts, we have roughly 670 judges. And whenever you have a case in a district court, you are going to have one judge residing upon each case. Think of this as the trial courts. And just when you zoom out a bit, you can see that there are roughly just under 900 federal judiciary posts at all levels. This is just that first level. Think of it as the entry point. If you have had experiences within the court system, you are most likely engaging with the district courts. But say you have a very specific case or you appeal the ruling provided in a district court, then you would move up to the next level, which would be the circuit, or also known as the appellate court. This is a court where you have a panel of 3 judges, not just one, and we have 12 different circuit courts within the United States, broken up with each district representing a number of states. So if you manage to obtain a ruling within the appellate courts, circuit courts, also known as, and then you would like to appeal that, you would then, if it was accepted by the Chief Justice of the Supreme Court, have your case heard by the Supreme Court. There is only one Supreme Court in the United States, and it is the highest court in the land. They will provide any landmark rulings, and the ruling that they provide is the final say provided by our judicial system until a new case is brought up that might relate similarly, but you cannot have the same case heard again. So we see this is the highest court in the land. 9 justices reside upon the Supreme Court, with the Chief Justice having significant powers over what cases are heard, and that is something we'll go in more detail on in just a few slides. But let's visualize this system before we just continue. So 3 layers. Again, like I said before, you have the U.S. district courts, 1 judge, 94 courts spread out throughout the entire nation. You have then the next step up on the ladder is the circuit or the Court of Appeals. This is where if you are provided a ruling within the circuit courts, it overrides the ruling provided in the district courts. And then you can move up the ladder once more to the U.S. Supreme Court. And again, if you have been provided a ruling by the United States Supreme Court, all lower courts rulings are then reliant upon the U.S. Supreme Court's rulings. So, state and federal courts. What's the difference? Well, one, we have to make some important distinctions, primarily based on how individuals obtain their posts within the state and federal court systems. So when we look at the states, we see that individuals are appointed by governors or selected through nonpartisan elections in various states. Montana is one of the states that has nonpartisan elections. If you remember from the past election process, you were asked to vote for Supreme Court representatives on the state level. Now, we also see on the state level, we do have interpretations based off of state laws and state constitutions. something many people overlook. Every state has their own independent constitution. Many states in the Southeast, in particular, had their own state constitutions that are still in effect today before the US Constitution was even ratified. So, state constitutions are what the judicial branch, the members of the judicial branch on the state level, must reference. And as we know from the Supremacy Clause, if the federal law does not address it, it is up to the state law. But if it is addressed by the federal law, federal constitution or statutory law, then the state courts must also rely on those rulings. So the difference on the federal level, we see federal judges are appointed by the president and then approved by the Senate. This is a process, if you remember when we were talking about the executive branch, encouraged the use of the nuclear option and in response to an excessive use of the filibuster in a select period of time for both federal judges during Obama's term and then for Supreme Court justices during Donald Trump's first term in office. So we see these appointments rely on approval by the Senate, which has in various moments brought some kind of problems, but also have never really pushed back that process significantly. And when we look at federal judges, once they've obtained their post, what do they reference? Well, of course, they reference federal statutory law and the federal constitution. Does not matter what the Montana state constitution says when it comes to a ruling in Washington, D.C. So we see the primary distinctions between state, federal, primarily relying on how judges within these entities get their posts and what documents and laws that these judges and justices, once appointed and once elected, reference. So, two different types of cases. Another key distinction that we will have to make in this course between a civil and a criminal case. Well, civil case, think of it as a legal dispute between individuals or entities regarding rights, obligations, liabilities. Oftentimes, when you look at the repercussions, they involve compensation on some level. You do not see individuals being imprisoned through civil cases, although you do see that occurring in criminal cases. And a criminal case, in contrast, is a legal proceeding, often brought by the government, against an individual or entity accused of violating a law. In a criminal case, there is a significantly high burden of proof. You've all heard the line in some TV show or movie, innocent until proven guilty. That is referencing a criminal case. You have a very high burden of proof. Possible outcomes, you see people experiencing incarceration, fines, probation, community service, and something we'll look at later on in this course, you can even see a possible repercussion of felony disenfranchisement, which is losing your right to vote, maybe even losing your right to possess firearms in certain states with certain laws. So we see criminal has very significant impacts on an individual's life if proven guilty, although it is harder to prove an individual guilty in a criminal case than a civil case. I like using the one example that there's probably like one or two of you that were around when this happened and you could remember it, but most of us were not even alive when this occurred. But the O.J. Simpson events. I know it's ridiculous. Why am I talking about O.J. Simpson? But O.J. Simpson, as you may know, in a criminal court was found innocent and not guilty of the acts that he was accused of at the time. But years later, he was tried in a civil court and found guilty for the same actions. So even if found innocent and not guilty in a criminal court and criminal case, you could have a civil case brought up against you, and it has a lower burden of proof. And we saw the impact of that case regarding O.J. Simpson. The impact was financial penalties, monetary damages that he owed to the family of the deceased. So one example that shows the difference between criminal and civil through something that caught the nation's attention, at least a little bit. And so those are the key distinctions when you look at the cases that people are tried for. Civil cases, oftentimes breach of contract, personal injury, like the O.J. example, it was personal injury of the family. You also see property disputes, family law issues. Basically, if you ever hear somebody say, I'm bringing you to court, it's likely a civil case. Now, if a cop yells that to you, it's likely a criminal case. Those examples would be murder, theft, assault, or anything that breaks a state or federal law. Now, when we talk about the judicial process, it's important to make sure we understand what our Bill of Rights and Constitution says about this process. So I like to just go through a slide with a couple of the amendments that really helped structure our judicial processes in the United States. So, Fourth Amendment, we remember this as protections against unreasonable search and seizure, and of course these are extremely summarized. There's more to these amendments than illustrated on this slide, but here is a foundation to make sure that you can ground yourself in when you start to engage with these. So the Fourth Amendment, unreasonable search and seizure, you have the right to your own, you could say, bodily autonomy without ever giving, as long as you have not given a police officer a probable cause or warrant to search. That is due to the Fourth Amendment. The Fifth Amendment, right to due process, protection against double jeopardy and self-incrimination. You've definitely heard the line in the movies, I plead the fifth. I plead the fifth. That means you have the ability and right to not self-incriminate yourself. You have the right to stay silent when asked questions about a possible wrongful act. There's far more than this than that to the Fifth Amendment as well. You also have the right to due process, uh, right to access the judicial system, and protection against double jeopardy, which basically states you cannot be tried for a crime, a single crime twice. If you are found not guilty and innocent of a crime, you are innocent of that crime and found not guilty. The state cannot bring that case against you again, although, as we see from the example I gave in the last slide, you can have a civil case brought against you, even if you've been found innocent of a criminal case. And the Sixth Amendment, right to a fair and speedy trial, public trial, impartial jury, right to be informed of charges, right to confront your witnesses, and right to counsel. This deals with a lot of the nitty-gritty when it comes to judicial process, fair and speedy trial, public trial. You have to be able to have access to a trial at a relevant speed. You cannot be put in jail for 3 years and then brought to trial. We see this being brought up here and there during specific cases. You also see impartial jury, right to jury of your peers. We have jury selection processes to ensure that this dimension of the Sixth Amendment is protected. Right to be informed of charges. You cannot be charged and arrested without being informed of what you are being charged for. Right to confront witnesses. No, you cannot yell at the witnesses, but you can ask them questions in a court setting. And then we look and right to counsel. You have a right to have a lawyer present and represent you. And the Seventh Amendment, right to a jury trial in federal cases, important regarding the distinction between civil and criminal cases. A lot of that expands the groundworks laid out by the Sixth Amendment. We see the Eighth Amendment protects against excessive bail, excessive fines, and cruel and unusual punishment. That's a fun one when we look at constitutional interpretation, whether you are originalist or living constitutionalist. We'll talk about that in just a few slides. And then the 14th Amendment expands due process protections and equal protection under law. We see this grants courts the power to review state laws that may infringe upon individual rights, and this has been relied upon in many, many Supreme Court rulings, some of which we'll discuss today. So, judicial appointments. How do you become a federal judge? Well, we briefly talked about this before. First step, you must gather the attention of a president if you hope to be a federal judge, because the president is in charge of judicial appointments. Of course, he references his cabinet or her cabinet when making this decision, and you do not have to be a close pal of the president as long as you have a track record that can catch their attention. Senate Judiciary Committees then debate the appointments. So remember, the Senate must approve all appointments made by the president. And we also remember the importance of committees. So judiciary committees will debate the merits and detriments of individual appointees. And then the Senate, once all debate has been concluded, will then vote on the various appointees. This happens with cabinet members, just like it happens for federal judges. And another point is we will not see presidents appoint every federal judge whenever we have a new regime in office. We look at a history of presidents appointing federal judges. We see George W. Bush appointed just a little over 320 federal judges in his 2 terms in office. Bill Clinton, 367 federal judge appointees in his 2 terms. Obama, a little less, 329 in his 2 terms. And Trump in his 1 term in office, not including the recent election, appointed 221 in office, federal judges. So you see this ranges. The amount of seats you can fill depends on timing, retirements, and once a federal judge obtains an appointment, it is a lifelong appointment. So we do not see term limits lining with various presidents. Instead, you see some retirements occurring at timely fashions during certain presidencies. If you look at, and those were the numbers I just gave, I apologize, those were regarding, actually, yes, that was correct. Those were all federal court judges. When you look at the appellate courts, Bill Clinton appointed 66, Bush 62, Obama 55, and Trump 54 in his 1 term in office, while all the others were in 2 terms. Trump with a heightened appointment power based off of timing, as you can see. And again, we remember it relies on retirement of various judges to fill those positions, or impeachments, because judges can be impeached. The U.S. Supreme Court. Okay, well, we just talked about primarily district and circuit court judges because there are hundreds of those posts that need to be filled every handful of years. But then we have the Supreme Court. This is a very important body within the U.S. government, as there are only 9 total members who are appointed for lifetime terms, just like other federal judges, and you see very little turnover within these positions. The first Chief Justice of the United States was also an author of our Federalist Papers, John Jay, the one that kind of falls to the wayside a bit, but we do remember and credit John Jay for writing about 5 Federalist Papers and representing those ideologies, being a large member of early American history and residing as the first Chief Justice in the United States. But let's fast forward a bit and look at who our current Chief Justice is. What is the Chief Justice? Simply put, head of the Supreme Court. We'll talk about that in more detail in just a slide. But the current Chief Justice is John Roberts, one of our 9 Supreme Court justices. 3 justices of our 9 total were appointed by Democratic presidents. We have 6 appointed by Republican presidents. We have established 9 Supreme Court justices in 1869, with a little bit of ebb and flow in the years preceding, but we have maintained this number quite consistently since. In 1789, the court was originally created with just 6 justices. In 1801, the number increased to 7 to be able to break ties. In 1803, for some odd reason, we reduced it back to 6. 1819, the court grew to 7 once more after we identified more conflicts that occurred when we were able to tie within our Supreme Court. Then 1837 comes across, and we increase the number to 9 justices. This is a power, of course, granted to the legislative branch, and we know at each of these time periods the legislative branch led these changes in the number of justices that reside upon the Supreme Court. In 1863, we see the number of justices for a very short period of time expanded to 10 justices. And then in 1869, the number was set permanently to 9, where it has remained ever since, as you see in that one slide. The Supreme Court in current years hears about 80 cases a year, but also relies on the enforcement powers of the other 2 branches to maintain the rulings that they provide. Theoretically, the court does not have an enforcement power and relies on the executive and legislative to enforce those powers. We see in recent years, at large part connected to the presidents that were able to appoint various justices, we have a Supreme Court that has a conservative leaning. This is an argument taken up within our textbook and various political science literatures in recent years, and I encourage you to look into it in more detail. Of course, it goes without saying, our Supreme Court is a body that is intended to not have any partisan affiliations, and although we maintain a conservative leaning within our Supreme Court, that does not have direct affiliations with the Republican Party. And our justices, every one of them, does not align with a political party. So, what are the requirements to be one of these Supreme Court justices? Well, none. Simply put, you have to be appointed and gain the position in the previously mentioned avenues. You have to be appointed by the president and approved by the Senate, but your qualifications prior to appointment could be anything under the sun. Now, in the past, we have relied upon people with experience engaging with the state, with experience as lawyers within our court system. So we do not see Supreme Court justices being appointed with little experience, although our Constitution does allow for it. We do not require a law degree and do not maintain an age requirement even. And once you obtain the office, as I've mentioned, you maintain a lifelong appointment. But I want to read a little bit of our Constitution and also emphasize some of the criteria that George Washington used when he was creating the first Supreme Court and appointing the first justices. So, quote, our Constitution says, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges both of the Supreme and inferior courts shall hold their offices during good behavior, they can be impeached, and shall, at stated times, receive for their services a compensation, which shall not be diminished during their continuance in office. End quote. And when we look at some of the criteria that George Washington used when determining who was going to reside upon our first Supreme Court, we see that these requirements included support and advocacy of the U.S. Constitution, distinguished service in the American Revolution, a requirement we're not going to be able to really maintain anymore, active participation in the political life of a particular state or the nation as a whole, so you have to be experienced in statecraft. You have to have prior judicial experience on lower tribunals. You either have to have a favorable reputation with his fellows or personally known by Washington himself, and you have to be geographically suitable. Original Supreme Court were circuit riders, and you have to have love of the country. Those were the requirements openly represented by George Washington when he determined the first Supreme Court justices, the first 6 to reside upon this office. Now, once you appoint these individuals, what is their job again? Well, their job is to interpret our Constitution and statutory law. They can take one of two approaches. Are we going to interpret our written law strictly as it was written, or are we going to have a Constitution that breathes with the challenges that new generations face? What do I mean by that? Well, let's rewind a bit to the beginning of the course and remember the differences between the Federalists and the Democratic Republicans. Remember, one side wanted a strictly interpreted Constitution, and the other wanted a living and breathing Constitution. Well, the strict interpretation, we remember that was advocated for the Democratic Republicans who wanted to use the Constitution to restrict the expansion of the federal government. And that was why they relied on heavily strict interpretations, as once you allow for the document to breathe theoretically, you also allow for those restrictions and barriers on our federal government to be relaxed. Well, if we were using these contemporary terms, we would call those individuals originalists. An originalist attempt to interpret the Constitution is relying on the specific text and the meaning that is fixed and implemented when it was written. Think of the extreme example of cruel and unusual punishment. The most hardline originalist would say that you can have cruel punishment and you can have unusual punishment, but you cannot have both, because the words the founding fathers used were and instead of or. So that, again, is an extreme example of the most extreme side of the originalism spectrum. And now on the other side of that spectrum is living constitutionalism. Every one of our Supreme Court justices resides somewhere along this spectrum, and none of them reside on hard ends of this spectrum. So originalists would heavily rely on every specific word used by our founding fathers, while a living constitutionalist would focus more on the sentiment and purpose behind each amendment or each statement within our Constitution. And the living constitutionalist would argue that constitutional law can and should evolve in response to changing circumstances and values. The purpose behind our Constitution is not fixed in any generation, but instead it changes so new generations can use this document to protect themselves. Now, we can look at a somewhat contemporary ruling. It's recent in my life. Some of you, this might have been right as you were being born. Crazy. But we look at the District of Columbia versus Heller. Without going into extreme details on this case, which I might be able to do in a little bit if we have time, we see that this was a case regarding gun rights in District of Columbia, known as Washington, D.C., as a police officer, simply put, had a private gun for when he was off duty, although the city's regulations did not permit private gun ownership in that form at that time period. So the ruling relied upon the text of our Second Amendment, and we see a divide between originalism and living constitutionalists in this ruling, as originalists had argued that the original text of our Second Amendment advocated for individual gun ownership in all circumstances, while living constitutionalists had a more they had a different interpretation focused on the development of contemporary societal challenges in relation to gun violence and how that allows for the regulation of ownership. The concluding ruling favored the originalist interpretation. The primary takeaway from this slide is not regarding this ruling, but instead regarding the differences between originalism and living constitutionalism. Strictly interpreting our Constitution as our text is fixed, or if you were taking the living constitutionalist approach, allowing for flexibility and allowing for our constitutional text to evolve with shifting threats. Now, let me rewind a bit to a point I mentioned a little bit ago, the conservative Supreme Court. Now, this is only worth mentioning because our textbook makes the argument, and there are multiple bits of literature published in recent years making this argument. And what they rely on when they make these claims is not who was appointed by who, but instead what when we do have rulings that are divided along these 6 and 3 lines, what are they addressing, and how often do we have these ideological divides within our Supreme Court's vote? So we have seen in recent years these divides, the 3 individuals in the picture and the 6 individuals on the other side of the picture. They tend to vote on various issues, not all, not even the majority of rulings, but they do have a significant number of rulings in which the vote is represented along these lines. And that is what has founded political scientists to identify our current Supreme Court as a contemporary conservative Supreme Court. We have had ebbs and flows within the ideology represented within our Supreme Court in our entire history. Think of the 1970s. We had a liberal-leaning Supreme Court with the majorities favoring that ideology and interpretation of our constitutional text. Very briefly giving you an overview of our justices, we have Chief Justice John Roberts, who you could say simply put leads the Supreme Court. We have Justice Clarence Thomas, who gathered national attention a few years ago. If you saw much about that, you have Justice Samuel Alito, Justice Neil Gorsuch, appointed by Donald Trump, Justice Brett Kavanaugh, also appointed by Donald Trump, and another Donald Trump appointment, Justice Amy Coney Barrett. And you may remember from recent years, the most recent Supreme Court appointment appointed by Joe Biden is Justice Ketanji Brown Jackson, who sits alongside Justice Sonia Sotomayor and Elena Kagan, who were both appointed by Barack Obama during his terms in office. We do see presidents being able to appoint anywhere from 1 to sometimes even 4 or 5 Supreme Court justices based off of timing, when past justices retired, passed away sadly, or when we had those very few limited times of expansion of the Supreme Court. Now, which cases reach the Supreme Court. We talked about the Supreme Court a lot, the individuals that make up this body, but what about the cases? Well, I mentioned they hear about 80 cases a year, but the cases that they hear are determined by the Chief Justice of the Supreme Court. The Chief Justice of the Supreme Court has absolute power to determine which cases are to be heard, and the current Chief Justice is old Johnny Roberts. Don't call him Johnny Roberts. I'm just saying that because I'm talking to a computer by myself in the corner of this room. John Roberts, our Chief Justice. So, when our Supreme Court provides a ruling that significantly changes the interpretation of existing laws, we do see that as a landmark ruling. We're going to go through a couple landmark rulings in the next few slides, but we understand them simply as rulings provided by our Supreme Court that have a lasting impact and establish a standard or test to be utilized by lower courts in future rulings. We'll talk about some landmark rulings to give you some examples now. Well, let's talk about one of the landmark rulings that has garnered the most attention in the United States in recent years. And I mention this to provide a little objective foundation on why the original ruling was provided and why there was the eventual overturning of this ruling in recent years. There is no place for opinion in this discussion today. I am simply citing what the Supreme Court stated as their reasoning behind these two rulings. So let's go in. Roe v. Wade addresses reproductive rights, or this issue that can be framed in multiple ways depending on your preferences. In this original ruling provided in the 1970s, we see the U.S. Constitution provided a fundamental right to privacy that protects a pregnant woman's liberty to choose whether to have an abortion, relying on the Due Process Clause of the 14th Amendment. We see throughout our Constitution, there is no clause that directly grants privacy to an individual's bodily autonomy, but we do see frequent mentions of privacy that if you use a living constitutionalist approach to interpreting our Constitution, you may see as warranting the right to privacy previously listed. To go through some of these, the First Amendment addresses the right to privacy of beliefs and privacy of group membership. Our Third Amendment addresses a right to privacy of the home when we talk about the Housing and Quartering Soldiers Amendment. The Fourth Amendment provides protection against unreasonable searches, right to be secure in your person's house, papers, and effects, so the privacy of your body when you are in public, or all things that you have ownership over, even when you are in public. Fifth, the right to privacy in personal thoughts and documents, as in, you cannot testify against yourself, also expands to provide that right to privacy. The Ninth Amendment, protection of rights not granted in the Constitution to be left up to the states, and the most important part of this, the people. This is your right to privacy in that sense, argued by some. And then we also see the 14th provides protections of privacy and personal freedoms. It says, quote, deprive any person of life, liberty, or property without due process of law, end quote, saying right there the expansion of these rights within the court system. Now, your interpretation of those rulings are whatever you desire them to be. You have the right to interpret that however you please, whether you take an originalist or a living constitutionalist approach. The only thing I ask is that you identify whether you are relying on an originalist or living constitutionalist approach when you identify these sentiments. The living constitutionalist, in this case, would argue that there is a right to privacy, while the originalist would argue that there was no direct right to privacy provided in the Constitution. In 2022, the Supreme Court that we previously discussed overturned the ruling provided in Roe v. Wade. In that case was titled Dobbs v. Jackson, the overturning of Roe v. Wade. The Constitution of the United States, in their rationales, they state that it does not confer a direct right to privacy of the body or right to abortion, and the impact of this ruling is that this issue is left up to the states, and we have seen numerous states implementing their various rulings and certain ballot referendums that have even been voted on in states like Montana regarding this issue. The purpose behind this slide is understanding what Roe v. Wade relates to, women's reproductive rights, and that it is currently not being implemented as it has been overturned in Dobbs v. Jackson in the year 2020. Originally, the ruling was founded off of the right to privacy, The overturning was founded off the concept that there is no guaranteed right to privacy within our Constitution regarding this issue. And yep, since to save time, I won't go into detail on other uh, other rulings relating to this issue, although if you're interested, I am more than happy to have a detailed discussion with you. Again, regardless of what your opinion is on this issue, it is important that we in government talk about the way this body, our government, regulates our lives, and this is one of those dimensions that is important to be able to understand and be able to engage with others who disagree with you. Remember the beginning of this course. Provide your definitions and try and access the definitions that others rely on that brought them to have such different conclusions. That's what I hope to do with this. Another landmark ruling that we're going to look at in this course. Lemon v. Kurtzman. Sorry that the last little word there is cut off, but you can see it says it right down there. So Lemon v. Kurtzman addresses the separation of church and state by providing clear standards. This Supreme Court ruling provided a Lemon test. This was referred to in various court rulings since the original ruling of Lemon v. Kurtzman. Lemon v. Kurtzman was a ruling provided in the 1970s as well by the liberal-leaning Supreme Court, and again, it has been overturned in the year 2022 in the Supreme Court case Kennedy v. Bremerton School District. So we're noticing a trend here. The two Supreme Court cases we're examining that were landmark rulings have also been overturned in the year 2022. In the overturning, let me backtrack. So the original case, Lemon v. Kurtzman, was relating to federal funding to private schools that were predominantly Catholic in a certain region of Rhode Island. So this encouraged individuals to challenge these funds. And long story short, the ruling stated that, okay, well, there was an excessive amount of federal funds going to private, religiously affiliated Catholic schools. So we need to maintain a test as a check to make sure that we do not fund religious affiliations and go against the First Amendment. So the test implemented by the Lemon ruling is the Lemon test. It has three parts. First, it asks, does the law have a secular purpose? If yes, then the law is warranted and can continue on. Second, does the law's primary purpose inhibit religion? Well, if it has a secular purpose, so a purpose behind it that is absent of religion, and its impact isn't favoring one religion over another, then it should be good. And then the third check in the Lemon test is whether the government is excessively entangled with religion. Does this action by the government, and this is the Lemon test should be implemented to any new concept, any new idea or law proposed. They should implement the Lemon test to see if there is an excessive intermingling between church and state. So it must have a secular purpose. It must not diminish the existence of an existing religion, and it must not maintain an excessive entanglement with the church and state. Well, in Kennedy versus Bremerton School District, they said this test was problematic. It does not allow for a true test to see if there was an excessive intermingling, and sometimes the argument in some eyes is that there must be some level of engagement between the two entities. Our Supreme Court in that ruling stated, quote, history, tradition determines scope of constitutional rights. I think it might have said one more word. My picture's cutting it off. I'll fix that by the time I make this a video. So we see that the Supreme Court ruled against overturning the Lemon test, and we no longer have the Lemon test in play. Kennedy versus Bremerton, the quickest overview I could give you on this is that this was a case in which an individual, a football coach, would go to midfield before and after games, and he would pray by himself, and this caught the attention of the team. And they said, well, if you implement the Lemon test on the actions of that coach while they are acting as a representative of the school public football team and representing an affiliation with the church through prayer, that means that would not pass the third test if there is excessive entanglement with religion and state, and stating that he has the right to pray in that setting due to the First Amendment, which overturned the Lemon test and provided the ruling that you saw in Kennedy versus Bremerton, which allowed him to pray while representing the public schools. So again, we see the lemon test no longer in play and has been overturned in the year 2022. Now, Plessy v. Ferguson. I could go on a long rant about the history and impact of this Supreme Court case, but we've already heard this in our high school history classes. I won't expect you to know any details on the quiz, but I do expect you to remember the overview of this Supreme Court ruling. So, in 1896, there was an individual named Homer Plessy, who was an activist that was an eighth black. He was what was known at the time as, simply put, passing. He could have been viewed as a white or black individual depending on the setting and the way in which he represented himself in these settings. And there was an act that was signed into law, the Separate Car Act of 1890. This allowed for segregation in railway cars. Well, Homer Plessy did not think this was a constitutional act and thought it is very clear that if this act is challenged within our Supreme Court, it would be deemed unconstitutional. So Homer Plessy, through an act of protest, went onto the railway car. As he took his seat, he notified the individuals running the railway car. I don't know what their position is. There's a name. I'm dating myself because I don't know what it is. I haven't been on a railway car. But he notified them that he was indeed African American and sitting in the white cart. So they arrested him. This eventually brought his case to the Supreme Court, and our Supreme Court stated that it is, let me see, I think I have the exact quote. The Supreme Court ruled 7-1, stating that, as we know, separate but equal is okay. But we do see the one justice who ruled against it, Justice John Marshall Harlan. He stated, quote, "The white race deems itself to be the dominant race in this country," and later referred to the Constitution as colorblind, identifying the detriments of race in early American history. We do see that this resulted in a period in which segregation, due to the landmark ruling provided by the Supreme Court, was constitutionally protected for 70 years. Since then, we have, okay, I need to edit the slide. I'll actually have it edited by the time you see this, so I shouldn't have even said that because it's gonna look perfect on your end. But segregation ended 61 years ago with the 1964 Civil Rights Act. So we have gone a longer period protecting segregation with our Constitution than we have gone with desegregation. So just one element in which our Supreme Court can reveal how recent some of these challenges that we believe to have conquered we faced. So we see that Plessy v. Ferguson was overturned in the ruling provided by Brown v. Board of Education in 1954, and which they state separate but not equal is not equal. And I will post on Eagle Online a clip that I strongly encourage you watch on Brown v. Board of Education that provides the overview, saves us the time so I don't have to ramble on about it, and they provide it in very good detail. The guy talks a little slow in the video, so I recommend watching it at 1.25 times speed, and it'll be like 8 minutes, and you will benefit from it. And it is important that we do remember the impact of Brown v. Board of Education, which desegregated the education system within the United States and other public access. Another Supreme Court landmark ruling, but actually the first in our list that has not been overturned. This is a ruling provided in 2015 in the case Obergefell v. Hodges. This is the Supreme Court ruling, landmark decision, that allowed the fundamental right to marriage to all individuals, regardless of your gender, sex, or abilities. And we see this was a 5-4 decision, relying on the Due Process Clause and Equal Protection Clause of the 14th Amendment, and the ruling was provided in 2015. Worth noting that we did not have guaranteed protection to equal marriage rights until the year 2015, in which Obergefell v. Hodges was ruled. and just barely made it through with a 5-4 decision. The only landmark ruling of those observed in this class that has not been overturned in recent years. This is I am going to save some time in this week's lecture since we're hitting the hour point and you have a lot to do this week as you're covering executive, legislative, and judicial branches and you're taking that quiz. I will not expect you to remember anything regarding this Supreme Court case, although it's a fascinating one that really helps us understand deeply the conflict on a judicial sense regarding private gun ownership, and it really reveals the divide within how you can interpret our Constitution between originalist and living constitutionalist. And as that point is already made, I will continue on from this. Of course, we know our Second Amendment, a very important amendment in our Constitution, regardless of what your perspectives are. And if you are interested in this topic, I am more than happy to sit on Zoom and talk to you, to just send some very detailed emails back and forth. This might help you work on your paper when we talk about, if your paper decides to talk about the conflict between security and liberty. This Supreme Court case is a great example to represent that discussion. And of course, we do remember that how this represents the divide between originalists and living constitutionalists, which are the two ways in which you can interpret our Constitution. Now, the final point we have to remember in these 3 lectures, how do the other 2 branches check the powers of this one branch? Because what we've done, we've looked at how the judicial branch can impact any dimension of our lives, from women's reproductive rights, your right to gun ownership, your right to marriage. It determines how we engage with ourselves, each other, and the state. But it's not to go unchecked. You also have to maintain, if you respect the words of our founding fathers, of James Madison's sentiment echoing that we need to have checks and balances in the Federalist Papers, you have to expand the powers of the executive and legislative to be able to check this judicial. So what can the executive do? The executive, for one, they appoint the judges. They have one of the most important powers when it comes to the judicial branch, which is appointment powers. The president can also grant pardons, reprieves, and commutations, overturning some of the rulings that could be provided within our federal court system. Again, it is important to remember that the President of the United States can only grant pardons, reprieves, and commutations for federal violations, although the head of the executive, who is that? That's the governor. The governor can do this for state crimes, but they can only do it for the entity that they govern. So that is one way in which the executive can influence the judicial courts by determining who reside upon those courts, and if there is a need, they can overturn dimensions of the rulings provided in the courts when you look at the individuals and their punishments. Now, what can the legislative do to act as a check on the judicial branch? Well, they do have to approve judge appointments, coattailing off of the power of the executive when it comes to the appointment powers. All appointments must be approved by the legislature, but that's not the end of their influence. They also draft the legislation that the courts must interpret. The courts cannot dismiss the statutory laws that exist in the United States when it comes to their interpretations of various cases. We also see that the legislative branch determines the number of judges on the Supreme Court. We had a little ebb and flow there. We started at 6, realized, why would we do that when we can have so many ties? Let's add 7. Let's go back to 6. Why? Who knows? I don't know. You could research it. There's reason. We could find it. I believe there was actually an individual passed, and we were not able to quickly appoint an individual in their place. But we also see we even had a period where we had 9. We expanded it to 10, 11 justices. So we see this occurs primarily due to the actions of the legislative branch. And then finally, just like how the legislative branch can impeach the president, the legislative branch additionally can impeach federal judges. This happens every blue moon when various ethics violations were committed. We have not seen it occur with a Supreme Court justice, although we have seen it with numerous federal judges at various points in U.S. history, but it is very important that this is an action led by the legislative branch. And they must go through traditional means of impeachment, which means they must go through the House and then the Senate, and majorities and 2/3 majority in the Senate for them to actually be removed. Now, what did we learn? I have not been running through these because, well, if you rewind the lecture, you'll see me rambling on about every one of these questions in excruciating detail. So make sure you go through and understand the impact of these rulings. The main takeaway from this week's lecture is understanding a lot of these Supreme Court rulings, how the Supreme Court operates, and the checks that the other branches have on the Supreme Court. Remember which of the court cases we've examined this week have been overturned and which have not been overturned. Look at them and think, what is the current law of the land in relation to this issue of gun rights, women's reproductive rights, religion, church and state, right to marriage? What is the final ruling? Look at the overview of the judicial, and of course, if you have any questions, just email me, and I will send you a way too long email rambling on about every little detail that I could think could relate to your question in any sense. Here are the answers to all the questions I just asked. And what is due this week? All right, so we have our traditional requirements of every week, discussions, make sure you contribute. We have a new discussion this week, so that's 3 posts, your original response, and then ask 2 different classmates a question about their original response. Go through the readings. The readings are important. I might, throw a little quiz question on the quiz referencing one of these readings. You never know. Also, we have our second quiz due by the end of this week, 11:59 p.m. All quizzes and assignments are due by 11:59 p.m. the Sunday they were assigned, so please make sure you get that in on time. And then really just start making sure you're at a good point in this course. We are just now hitting our halfway point, so make sure you're really thinking about that term paper. You're prepared to write a 4 to 5 page paper, and ask me any questions you could think of that could help make that process easier for you. I'm not doing this assignment to catch those of you who aren't good writers. Instead, I'm doing this to hopefully improve all of our writing. I benefit from reading all of these essays, and I hope you benefit from the comments that I give you as you're working on these essays if you reach out to me, which is something I recommend. You have a great resource here. The person who's even going to be grading your work is willing to work on it with you. Take advantage of that. Reach out to me and let me help you, and we'll end this. Have a good paper, maybe something you can add to an application one day. So use the resources available, which are me. We got this. Thank you for listening to me ramble on for another week. I will talk to you next week, and hopefully over the next few days via email.